to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of our little podcast here.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Yes, I do. Though today it's going to be a little more legalistic than prior ones, because once again we're going to talk about Tornetta v. Musk.
Yes, and then the CEO who provides endless fodder for commentary.
It's like a bad penny. It just keeps coming back. But it's really fun, actually. There's a lot of interesting stuff going on. This is, of course, the case that challenged this mega executive comp equity award to Tesla CEO Elon Musk from 2018. And there was some interesting stuff in the past few days. Yes.
There was a new decision that came out that gives everyone a lot to think about regarding Tesla and Delaware and all those kinds of subjects.
And boards of directors and all sorts of fun stuff to consider. So one more bite at this little apple, at the this fascinating, important case. Let's real quickly just recap what happened last week.
Okay, so what happened last week was that Chancellor McCormick finally issued her opinion on the shareholder revote to approve Musk's pay package. So we talked about this in our very first episode. But for anyone who needs to catch up, Tesla's board agreed to a compensation package for Elon Musk in 2018, and the package was performance-based. For every $50 billion he added to Tesla's market capitalization, he'd get more stock. And in total, if he hit all the milestones, he'd receive the equivalent of about what was then $56 billion in stock. I think at current prices, it's somewhere like $100 billion.
It's about $100 billion.
Yeah, so this pay proposal...
Tesla's had a good run in the past couple of months.
Yeah. This proposal was submitted to shareholders in 2018, and they approved it. But a shareholder sued, saying that the board was captured by Elon Musk, and the shareholder vote that was in favor of it was not fully informed. And there was a whole trial, a bench trial, meaning no jury, because that's how things work in Delaware. But
in Delaware Chancery Court.
Delaware Chancery Court
is no juries. It's only the judges.
It's only the judge. So the whole trial was held before Chancellor McCormick, and the shareholder won. Chancellor McCormick agreed that the board was not independent and the shareholder vote was not informed. And that meant that under Delaware law, there was no independent decision maker at the company who had approved this pay package. And without an independent decision maker at the company to approve this pay package, that, under Delaware law, left it to the court, because there's no one else. The shareholders can't do it and the board can't do it. So the court had to decide whether the package was fair. And Chancellor McCormick determined, no, it wasn't fair. Yes, the shareholders got tremendous value. There is no question they did. But it wasn't obvious they needed to pay Elon Musk quite so much to get there. He might have done it for less. That was basically the logic.
Or more specifically as well, the board, Chancellor McCormick also found in the facts that the board didn't negotiate this at all.
They didn't negotiate.
They had a fiduciary duty to negotiate hard, and they negotiated like not at all.
They negotiated at all. And that's the point, that like normally we would defer to the boards. Like we wouldn't even ask this question. The only reason we're even here with what Chancellor McCormick thinks is because the board essentially was captured by Musk. So that left it to Chancellor McCormick to step in. And she concluded that since he owned 22% of Tesla in 2018, he already had plenty of incentive to increase Tesla's market capitalization. Every time he increased it, like for every milestone, he got $10 billion additional wealth without any additional grants at all. So Chancellor McCormick thought, you can't prove to me that this was necessary to pay him quite so much. So she rescinded the pay package. And normally when that happens, the losing side just appeals, in this case, to the Delaware Supreme Court. But instead of doing that, Tesla tried to redo the exact same package. They figured if the problem here was a captured board and a misleading proxy statement, maybe they could fix those things. So they created a new board special committee consisting of only one person, Kathleen
which we've talked about.
We talked about one person special committee. And this committee of one person had a very limited mandate. She was only supposed to evaluate whether the grant should be restored. She wasn't supposed to evaluate the amount and terms of the grant. And I don't really understand how you do that, but that's what she did. She was supposed to
That was the committee's mission. Go ahead. Yes.
Exactly, to decide whether it be restored without actually evaluating it substantively. And she recommended it be restored, and the shareholders voted to restore it. And so Tesla went back before Chancellor McCormick and argued, see, now the shareholders are fully informed.
We're kosher. The shareholders love it. Right.
Yeah, exactly. They attached her opinion to the proxy statement so that Tesla could say, see, hiding nothing. Everything you found is right there.
Everything's disclosed here.
And so, therefore, we've corrected all the flaws in the original process. So Chancellor McCormick had to decide whether this new vote would force her to revise her original judgment and restore Musk's pay. And either way, she had to make a decision about what kind of attorney's fees would be paid to the plaintiff's attorneys. And that's what she reached last week. And she held, no, Musk does not get his money back.
Yeah, she basically said, get out of my courtroom.
Exactly.
I don't want to see you about this again. Remember what I said? So just for timing perspective, the original opinion that she issued about the independence and so forth was in January.
Yeah, it was January of this year.
Tesla then held this vote at its regular June shareholder meeting.
It was. So I guess the proxy statement came out in April.
Proxy statement was, so the disclosures were in April, and then everyone voted in June. They voted again. They supported it, just like they supported it in 2018. They then, right away, Tesla marched into court and said, see, we got this positive vote. And Chancellor McCormick said, okay, see you in August. And then in August, they had a hearing. Nope. About the arguments about whether this vote, in fact, made everything kosher again. And now, finally, after 3-4 months, Chancellor McCormick has now issued her opinion based on what she heard at the hearing and all the briefs and all that kind of stuff.
Exactly.
Okay, good. And the hearing covered two things. First, the hearing said the vote didn't matter, and then the hearing also said these are the legal fees that people can get.
Exactly.
What happened with legal fees?
Well, no. You want to talk about the legal fees and not the opinion itself?
Oh, no, let's talk about the reasoning for the opinion. Sure. Let's go. Oh, yeah, that's a good point. Let's talk about the bases for rejecting this overwhelming vote. And there was a lot of news after the vote came out. Musk was jumping up and down saying, see, shareholders love me. And there was, I guess, the chancellor received thousands of letters from shareholders.
A lot of it was also about fees. A lot of it was like, we did not want this case, so therefore don't pay them anymore.
Right. Yeah. But in an unusual twist, Tesla shareholders really, they basically were protesting to Chancellor McCormick, hey, this is what we want. Mm-hmm. And Chancellor McCormick said, not so fast, people. Yeah. And what was the basis for not so fast, people?
Okay, so the short version, and again, we talked about this in our first episode because she kind of was telegraphing her thinking at the hearing. But the short version, she held too little too late. Right. The revote was the equivalent of Tesla introducing new evidence to the court, new facts for her to consider.
Interesting.
And there is a procedure for introducing new facts to a trial court, and it's not after the trial is over and a verdict is reached. So if Tesla wanted to hold another shareholder vote with better disclosures, the time to do that was before the trial, not after. And there are a lot of practical reasons for this rule. Waiting until after trial wastes judicial resources, it wastes the court's time, and that might sound like unimportant, but I assure you there is a huge legal infrastructure built up around forcing litigants not to waste the court's time. There are lots of legal rules that say make your argument at the appropriate time or lose it, precisely because courts have a lot of cases and it's really important they have a clear idea of the issues they have to decide.
Right.
Plus, allowing defendants, Tesla, to raise all these new arguments with new facts, that's prejudicial to the plaintiff because the plaintiff thought this was over. They developed a whole trial strategy based on the record that existed at the time, and now there are all these new facts to examine. And this is a point that the court made explicitly. When plaintiff's attorneys take these cases, they're on contingency. They get paid a percentage of what they win, and they get bupkis, 0 if they lose. Now, we can have a broader meta debate about the value of shareholder litigation in general, but Delaware has institutionally settled on a system where shareholder litigation is a crucial part of how shareholders' rights are protected. So let's start as that a baseline. It's important shareholders can bring their cases. But these attorneys who work on contingency, they're not even going to take good cases if they think they have to take these huge risks at trial and expend all this money to win. And then instead of getting paid, the company just says, okay, wait, let's have another vote and do it again.
Or bring some other evidence or some other facts.
Exactly. So that will prevent plaintiff's attorneys from even risking a lawsuit in the first first place. And so those were the reasons she refused to restore the pay package. There were some other reasons, but those are really the headline reasons that were the important ones.
There was one that, in my read of the opinion she just issued, there was one about the disclosure that I don't think was quite expected.
It was, but
she didn't really telegraph that. I don't. Think.
So this gets kind of complicated. You have to So okay, we have talked on this show a lot about cleansing conflicted transactions involving controlling shareholders. So normally, if there's a conflicted transaction with a director, just one director, you either need independent shareholder approval or independent board approval. But if it's a controlling shareholder, you need both shareholder approval and board approval.
Right.
And or independent, And Tesla, and she had concluded previously that Elon Musk counted as a controlling shareholder, so he needed both the independent board approval and the independent shareholder approval. He didn't have either, so it doesn't really matter that she called him a controlling shareholder because she concluded he didn't have either. But theoretically, because he's a controlling shareholder, he needed both independent board approval and independent shareholder approval. So Tesla argued, well, now we have that. We have a new vote. We have an independent committee. So now we got this independent board approval through this one person, and we got disinterested shareholder approval through the shareholder vote. And McCormick held, well, no, because that whole transaction was still tainted by the original grant. This special committee person, she didn't reevaluate the grant. So the original grant was still tainted by
the bad... She explicitly said we're not
she
redoing...
would not. She explicitly said it. She didn't hire a compensation and so forth. So that meant from McCormick's perspective, even if Wilson Thompson counts as even if the board thing was cured, the whole situation was tainted, which ultimately meant that even the best shareholder vote couldn't... restore the pay package because Musk was a controller and you didn't fix the board level price. So ironically, then the final aspect of the decision was, since a shareholder vote in this circumstance could never have cured the problem because Wilson Thompson never revisited the original package, McCormick held that therefore the proxy statement was misleading because it said if there's a shareholder vote, it'll fix everything. And McCormick said, no, it wouldn't fix everything. It never was going to fix anything. So you've now said, now you've lied to shareholders by giving them the sense that their vote was worth more than it actually was. Now, obviously that language is circular because if the Delaware Supreme Court disagrees with her about whether the pay package can be restored with a new vote, then the proxy statement wasn't misleading. But I actually think that's really less important than the headline, which is you can't do this late in the game. Right.
All right. So that's the reasoning for rejecting this vote.
Exactly.
Let's cover for a sec, because you also mentioned that, and this is a huge part of these proceedings, is how much the lawyers get paid.
Yeah.
And they were looking at a lot of money for a moment, and they're still looking at a lot of money, but a little less.
I'll take it. Absolutely.
Right.
No.
Me too.
Okay. So there are people who specialize in fee awards, and they are not named Ann Lipton. So I don't have a whole lot of insight here, but the headline here is the plaintiffs' attorneys argued that they got $56 billion for the stockholders. Because of their efforts, Tesla was spared having to pay Elon Musk the equivalent of $56 billion. And so they were asking, they said, for a very modest 10% of that.
Just a fraction.
Yes, $5.6 billion in Tesla stock, or alternatively, $1 billion in cash. She didn't give them that. She awarded $345 million, which Tesla can pay in either stock or cash, which is a lot less than the ask, but I think the biggest award in Delaware history.
Right.
That said,
the biggest award of legal fees.
Of legal fees, absolutely. But here's what really stood out for me. One of the arguments over the fee was how much benefit do the attorneys really achieve for shareholders? Because the idea here is the higher benefit they get for shareholders, the higher the fee.
Yeah, they should share in that.
Exactly. Yes. So the plaintiff's attorneys said, we got $56 billion. That's what we got for shareholders. And the defense argued they didn't really achieve that much benefit. And part of the reason they didn't was because this wasn't anything shareholders valued. This wasn't something that the market took seriously. And the defense evidence was, look at the stock price. If shareholders really thought that this was a valuable win, then you would expect Tesla's stock to go up when the verdict was announced. And that didn't happen here.
Right.
But McCormick pointed out you can't really gauge the value of the verdict by the stock price reaction because Elon Musk tweeted these confounding things when as soon as the verdict came out. He tweeted he'd move the company to Texas. He tweeted if he didn't get his stock, he wouldn't develop AI. So maybe the market was reacting to his threats and not the actual verdict. You can't tell what the pure stock price reaction to the verdict would have been because Elon Musk was tweeting. And I think she would have reached the same conclusion regardless, but it's just funny that he was specifically foiled by bad tweets.
Right, and that's a very common problem in trying to use share price.
It's always a problem with trying to use, but it's just
in trying to assess the impact of events. Event studies are they're good, but they really vary. And event studies done by the Chancery Court.
Well, yeah, and it's a big thing. It's securities litigation and federal securities litigation. They're always this is always an issue. But I just think that it's funny that Elon Musk specifically shot himself in the foot with bad tweets, which is something that happens.
At least according to her. Sure.
Yeah.
Right. So we're down to $345 million in legal fees, and there was just an alternate formula that she employed to get there. I know she used the grant date value rather than
instead of saying they won $56 billion, she said they won like functionally $2 billion, which is about what the grant was worth at the time it was.
Well, that was the accounting charge.
Yeah.
That Tesla took when they booked the grant in 2018. And that, in fact, is what they will, whenever this is final, that's what their accountants will require them to reverse. So they're going to get a non-cash, at the time it was a non-cash charge of about $2.3 billion, and then sometime when this all gets wrapped up, and assuming it stands, which we're going to talk about in a moment, that it'll be it'll be about a $2.3 billion non-cash gain.
Yeah, so that's what she used as to base her fee off of.
Right. Cool. Why don't we we want to talk about what's kind of next, both in Delaware, I think, and then also next for the company and Tesla and his and more comp for Elon. Let's do that after a quick break.
Sure.
Shareholder Primacy is brought to you by FreeFlowAnalytics.com, the only free database of corporate directors, their influence, and their performance. If you own a stock or retirement plan, go to FreeFlowAnalytics.com and look up which of your elected directors are performing well and which aren't. Use your vote in the alternative democracy and get your data at FreeFlowAnalytics.com. Now, back to the show.
Okay, welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin, and we're still talking about Tornetta.
There's a lot to think about here. We left talking about what had happened. Let's talk about what might happen next. First in Delaware.
Yeah.
Clearly, Musk said he's appealing this. He said it's not done. He's going to appeal. He said, he tweeted when the opinion came out in January, I'm going to appeal. I think he tweeted last week, I'm going to appeal. So what does that look like?
Okay, well, Tesla's going to appeal. So when it does, the Delaware Supreme Court has to consider whether McCormick was correct the first time, whether this pay package was unfair after trial. And they'll also get to consider what effect, if any, this new vote had. So both of those issues will be before the Delaware Supreme Court. And I hate making predictions because how embarrassing if I'm wrong. But I really don't.
We're gonna talk. Let's speculate.
On this, I will make a prediction. Tesla's not going to win on the revote issue. If Tesla wins on appeal, it's going to be about the original trial ruling.
Okay.
Yeah,
why not on the? You seem pretty confident, and I share your confidence on the revote issue. Again, not the lawyer in the podcast, but everything I read and saw suggested that the revote did not make this original breach of fiduciary duty any better. And then there were some additional flaws in the revote.
Well, that's exactly the issue. So you have to think of it this way. So McCormick didn't even address all the arguments about the revote. For example, the plaintiffs argued that even if you can reverse a verdict this way, in theory, that this particular vote wasn't good enough. Why? Because Musk coerced the shareholders. He kept threatening that if he didn't get his pay package back, he would refuse to develop AI at Tesla. And so a shareholder vote can't ratify anything if shareholders are being blackmailed. Also, what about that special committee member, Wilson Thompson? Was she really independent? What if she was beholden to Musk because she was getting hundreds of millions of dollars in stock? And McCormick didn't even address these arguments because she didn't have to. But if the Delaware Supreme Court decides, actually, we think, in theory, you can undo a trial verdict with a new vote, then it's going to have to address these arguments that the vote was coerced, the special committee was beholden, but it can't address those arguments. Not really, because that requires facts, factual determinations, a hearing. What did Musk say? How was it perceived by investors? What was Wilson Thompson's mindset? And the Delaware Supreme Court can't take new evidence, so now it has to remand to McCormick to
I was going to say remand.
The evidence.
That's the verb. We're going to remand it.
Exactly. And that's the problem. Any new vote at this stage, the plaintiffs have to at least be permitted to argue that the proxy was misleading or the vote was coerced or whatever. And there's no way to decide that without a whole new trial. So now we're just endlessly trying this one case, which is exactly why you don't allow the new vote in the first place.
And the Supreme Court is as sensitive to this to use of judicial resources as Chancellor McCormick at the Chancellery.
The case would never end. So Tesla was really doomed on this when their attorney conceded, as he absolutely had to do. There was no question. He had to concede it. That when the plaintiffs challenged the new vote as coerced, those allegations had to be evaluated the same way you would a shareholder complaint, which is a pretty loose standard where you allow a lot of inferences in the plaintiff's favor. But a complaint is just the beginning of a lawsuit. After that, you have discovery, depositions, you have document review. There's no way Tesla could seriously expect that we're going to do all that again and again and again. So that's why I don't think this argument can win. If Tesla wins the appeal, it's going to be because of arguments about the original trial, not the revote.
And those arguments revolved around, and you and I have talked about this offline, and I've read about it. In particular, I think the main one has to do with the nature and extent of Musk's control.
See, no. I mean, it's been, we've talked about controlling shareholders a lot, but I keep trying to avoid talking about that with this case because I don't think it matters in this case. Remember, if you are not a controlling shareholder, if you're just an ordinary director, you can get your conflicts cleansed either by the independent boards or by the disinterested shareholders. Vote. If you are conflicted, you need both. The problem is that Musk didn't get either, according to her. So you can call him a conflicted controller or you can call him just a conflicted director. It doesn't matter. He didn't have an independent board approval and he didn't have disinterested shareholder approval, according to McCormick. So as far as the appeal goes, I mean, again, I don't like making predictions, but here's how I see things. She reached certain factual conclusions about the board being captured by Musk. Not just they didn't negotiate, but they didn't negotiate because he completely controlled their deliberations. So she read those. And she made factual conclusions that the proxy was misleading. In general, the Delaware Supreme Court on appeal should defer to those findings. She was the fact finder. She took evidence. And the Delaware Supreme Court tends to, it doesn't have to, but it completely accept them, but it tends to defer to her factual findings. So I think those stands. Now, there are places where one could quibble. She found the proxy statement was misleading because it described the board members as independent when they were, in fact, captured by Musk. Now, one could reasonably argue that the ties among board members was already known to the shareholders. Like, nobody was fooled and thought that this board wasn't captured by Elon Musk.
No, Kimball Musk on the board.
Yeah, well, there was also the committee. He wasn't on the committee. I know. They were all his associates. You could reasonably say that nobody was misled by this proxy statement that the committee was independent because everybody knows that, of course, nobody's independent on that board. So you could argue there's nothing materially misleading in the proxy statement. But that wasn't the only basis for finding the proxy statement was misleading. She also found it was misleading because it obscured the fact that his entire pay package was proposed by Musk, as you said, without any board pushback. And actually, what I love is that the original draft of the proxy made it clear that Musk was the one who proposed this pay package, and the board didn't change it. Later, they changed the proxy statement language to obscure that Musk was the one who came up with this, which, I mean, she didn't find it, but that to me suggests there was actually an intent to mislead shareholders.
Yes.
So these kinds of factual determinations, was the board captured and was the proxy statement misleading? The Delaware Supreme Court's going to review them with deference, and I think they're likely to stand. But those are facts. They led to specific legal conclusions. The court couldn't defer to the board's judgment because the board was captured, and the court couldn't defer to the shareholders' judgment because the shareholders was misled.
Was misled, right.
Right, so that left it to the court to judge, is this pay package fair? Normally, you defer to the boards or you defer to the shareholders, but you can't here. So now the court has to decide, is this pay package fair? That piece Was the pay fair despite the problems and how it was negotiated? I think that's the place where it's most likely the Delaware Supreme Court disagrees with her. Her logic, as I said, was Musk would have increased Tesla's market capitalization anyway. He had a lot of incentives to do that. He didn't need $56 billion. I don't know if the Delaware Supreme Court's going to see it the same way. So the court, it has to defer to her factual findings, but I don't think it has to defer to that general balance. Was this fair given these facts? So I hate predicting outcomes, but if you held a gun to my head, I'd say that's the spot where she's most likely to be reversed. If she's reversed at all. I'm not saying she's going to be reversed, but if she's reversed, that's where I see it happening.
Got it. How long is this going to take?
Oh God, at least a year. We're going to be here for a while.
You're in Delaware. Yeah. Okay. Let's the next move, assuming we're done talking about Delaware.
That's all Delaware.
I mean, for now, there's been, and I've thought about this as a shareholder too, and I don't want to pay Musk anything more, especially because he's not really there much these days. He hasn't come to the office. Really.
But I still think, nonetheless, you could say he's pretty much working for Tesla in his current role within Trump administration.
Sure. His current.
He's doing some good for Tesla.
His current assignment.
His current assignment
in Washington may help Tesla in some ways. Yeah. So, but anyway.
But the question everyone's asking now is, well, if the board can't reinstate the old package, could it just say today, in 2024, we're giving you this grant of stock? Can it do that? I mean,
absolutely. The board, again, subject to the need for approval, which has been the subject of this and many other things. Yeah. The board has complete latitude in how they compensate people. Okay, and. The board gave him in 2018 a grant that was fair valued at $2.3 billion that grew and grew and grew. They could easily, there is nothing to prevent them, particularly as respects shareholder sentiment, from doing that again. I mean, Tesla's had an unbelievable run in the past year. It's up, it basically doubled this year. Mm-hmm. So shareholders in Tesla are elated. Again, whether they're related because they finally figured out cars, which they quite really haven't quite yet, or because, there's all this, potential prospect. Again, Tesla trades much more like a tech company than a car company, though basically it's in the business of making cars. So my sense is that shareholders will gladly, they'll approve anything. Look, if they approved a move from Delaware to Texas and re-ratified this, after this, they'll approve a new package. Now, the question is, what does that look like?
What does that look like in 2024, handing him what is now $100 billion worth of stock?
That's a big problem. Okay? There's actually two problems with that. At least two problems. First is that the cost to Tesla is immense. In 2018, as we talked about, the cost at the time was about $2.3 billion, and that's a non-cash charge. It was just basically the cost of equity. It was the fair value.
Because it was an option grab, because maybe he wouldn't get it. Exactly, so it's $2 billion, not $56 billion, because of the uncertainty of whether he'd achieve it.
At the time, I haven't seen a reanalysis of this. At the time in January, when the opinion first came out and people were starting to re-estimate, okay, let's suppose, and this is before they moved to Texas. The Texas move doesn't matter to this particular question. There was an estimate that just redoing this grant, the exact same 12 tranches of equity, and basically it's about 300 million Tesla shares. At the time, would have cost Tesla about $25 billion in grant date fair value, non-cash, but a huge accounting charge.
Right.
Okay, it's probably higher now because of the run-up in
because the stock is
Tesla stock. It's because it's worth more now. So, and there's a good, part of the problem is that the Tesla board probably can't, look, Elon doesn't need it. He wants it because he wants control over the company, not because he needs the money. All right.
I think he likes the money too.
He likes the money, but he's got, look, he's monetizing all sorts of, he's about to, he raised another round in XAI that just raised a huge amount of money. That, SpaceX is worth, more than it's than his investment in Tesla at this point. But it's mostly because he wants the control. All right, and again, and the shareholders are totally happy having him have that. But the grant date fair value of an equivalent, 300 million shares is probably, 50, 60. It's a huge amount of billions of dollars that like overwhelms Tesla's economics.
Right.
The charge that quarter comes through is going to be one of the ugliest in any company's history. Again, it's non-cash and so forth, and shareholders kind of understand it, but you can't look beyond the fact that we're still dealing with a car company that's got some really cool AI rather than a tech company that continues to carry multiples and valuations that make it look a lot more like Microsoft and Facebook than GM and Stellantis. Right. So anyway, so that's economically what shareholders are looking at, assuming that the board, and it's a good assumption that the board's going to want to do this. The board does whatever the board does whatever Elon asks, and if he says, "Look, I want my control," because right now his shareholdings I think is somewhere in the range of about, assuming this sticks, the decision takes away 300 million shares. His 400 million shares remain, I think, at 10 or 11 or 12%. Okay. And he has said publicly he wants about 20%. That's what it would take for him to motivate him.
And that's because he left Delaware. If he had stayed in Delaware, he could form a shareholder agreement and give him the same
of
control.
Course.
But
anyway,
he can't do that
but now that they're in Texas, let's my assumption is that Tesla shareholders that the board's going to give them something here. I know it's going to look like it, maybe after the appeal, but it's going to look like some. And immediately someone's going to try to sue it. Sue to stop it. That's where things get really interesting because they're suing in where? Texas,
exactly. So
in the new business court. So let's talk about that for a second.
Yes, all right, exactly. So Tesla isn't a Delaware company anymore. It's a Texas company. Any new award that's given to Musk today is going to be subject to Texas law, and any challenges to it by a new shareholder, which will certainly be tempted, will have to be brought in Texas courts. So there are a couple of levels on that. So first, that's already going to hurt any new plaintiff's chances because Texas has these specialized business courts, but they're very, very new. The judges are appointed for only 2 years at a time, which means that they're very much under the control of Governor Abbott. And I think we've all been assuming, and I think Tesla has been assuming, that these judges are not going to be very sympathetic to shareholder claims brought against the state's favorite son. So the issue here is we're already got judges who we can assume are not going to be particularly welcoming to new claims. And at the same time, Texas's law is actually pretty underdeveloped. Everyone's law is underdeveloped except Delaware's. So there are a lot of questions about how courts would interpret Texas law. And there are a couple of different issues here, but the really big one is independence. If shareholders want to bring a claim, they will have to show that the board members are not independent of Elon Musk. So now we have to ask, what does independence mean in Texas? We know what it means in Delaware. It means that there's a reasonable doubt someone can be impartial when making a decision. And we've said in prior shows, this is actually a very fact-specific standard. Delaware doesn't just look at things like business relationships, but also how business intersects with personal relationships to figure out if two people are too close to be able to consider matters impartially. Like in one case, two people co-owned an airplane together, and they were assumed to have a very close friendship because people who own airplanes together, they obviously you've got to coordinate that. In another case, two board members visited each other's homes, grilled steaks, and, I swear to God, castrated calves together.
Excellent.
Excellent. And Delaware said, well, if you're castrating calves,
if you're going to be doing animal husbandry that way together, I suppose that means you're not independent. Okay,
good. Not independent. So Delaware looks at these relationships and says, okay, you're too close to be impartial. But Texas has a statute on this. And Texas's statute says independence means no, and I'm quoting, business, financial, or familial relationship with someone that would affect their judgment, and no relationship that has one person under the controlling influence of someone. Is that different from Delaware law? Well, business, financial, familial, that sounds like narrower than Delaware's because it doesn't seem to include friendships. Business, financial, familial does not sound like, people who castrate calves together, at least not on its face. But
Right.
then there's that extra piece, the existence of controlling influence. You're not independent if you're under the controlling influence of someone. That could include personal relationships, but sounds to me, like a very high bar because
Right.
people
And
can
there's
be friends.
and there's no law yet on it.
Yeah,
there's no
exactly.
cases,
There's absolutely
there's
no law.
nothing.
I actually did I didn't research this the way an actual plaintiff who was litigating the case, so there might be out there that I didn't find, but I couldn't find any case law that interprets this language. And this is exactly the kind of flexibility that would protect Musk, especially if the judges are inclined to be sympathetic in the first place. But there's a punchline. When Tesla asked shareholders to vote to relocate the company to Texas, it included these reports in the proxy statement on what the impact would be on shareholder rights. And the reports...
Oh, that was from the
stated-
committee. From the committee
the
wrote
had
these
to
reports.
It got an expert from a professor, and then there were ISS and class, and all these different commentary. Like, what does this mean for shareholder rights? And it said explicitly that Texas provides substantially equivalent litigation rights. So if I'm a stockholder bringing a lawsuit, I would argue Tesla is actually barred from arguing in a Texas court that Texas has a materially different standard of independence than Delaware does. That's what I'd argue. That Tesla is now bound to that representation that shareholders have the same rights.
And you
That's
did
what I'd
this.
argue.
A while ago, you in fact helped write these arguments.
Yeah,
when
I
you were in
helped write
practice.
these arguments once upon a time, many years
Yes,
ago.
right.
So that's what I'd argue, but we'll see what happens.
So that's interesting. So essentially, and there's lots of states that do this, that say we're going to defer to Delaware law.
Yeah, Texas always has in the past. It's looked to Delaware case law.
Right. So there's a lot of states that sort of copy or follow or emulate Delaware law because it's so established and so forth.
Yeah, corporate law is incredibly underdeveloped outside of Delaware.
And Texas, in fact, did this for a while. And then they created these new business courts, which I'm sure got Elon's attention. Said, "Oh, cool! I can do anything I want now." but the challenge is that he disclosed to shareholders, or the company disclosed to shareholders, that in fact we're going to move here, and we're promising you.
Well, yeah, I mean, there was the argument about how much of a commitment was it, but
Right.
like we believe, so like was it a commitment?
That,
was it not
that
a commitment?
we will follow. We will not be any worse than Delaware, which is basically
yeah,
we're going to continue to follow Delaware law.
Yeah, and that's what I would imagine plaintiffs would argue. Now, of course, Tesla will say, "Look, this was a prediction of what courts would do, not a promise." Blah blah blah. But it will still, it would be funny to see it play out that way, and it could.
Wow. All right. All right. So we're going to wait for this appeal. We're going to wait a while for this appeal, and we're going to also see what happens next. And my guess in Texas, that is, and my guess is that Tesla probably will wait until after this appeal gets worked out.
Very possibly.
They don't. I mean,
if the Delaware Supreme Court reverses and gives them the money
right,
back,
they don't want to give two. I mean, they could try to do something funky like make a new award contingent on the work out of the appeal, but no one wants to go there. And again, Elon doesn't need the money. He just wants the control. He kind of has the control, so he's not going to worry too hard about it for now.
Yeah.
So, and then there's all sorts of implications that we can talk about, like what this all means for Delaware and so forth. But let's do that at another time. Let's do that at another episode. How's that sound?
All right.
All right. Let's wrap up. I'm tired.
Okay.
there's a lot to think about here. Okay. It's been terrific talking about this. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and advisor to investors about their activist situations. Ann, of course, is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute, but not for the rest of the month because classes are over. and Ann gets to just write her papers and tidy up and
great
exams. You can find me, Mike, at theactivistinvestor.com and Ann at law.tulane.edu. Our podcast is produced and distributed by Free Flow Media. Thanks for listening. Let's talk again.